Hello everyone, today I'll be sharing another legal story with you. So basically, I have referred this case from a site, but the name of the case was not mentioned there. So I'll be unable to share the name of the case, but the matter was important and there are a lot of learnings from this case, right? So let's inculcate certain important learnings from this case. Okay, so basically on 19th September 2025, matter was pending before the Punjab and Haryana High Court. Okay, right, and let's understand this the background of this matter. So basically the complainant and the petitioner, they were both were friends. Okay, later they got engaged, right, and they entered into a consensual relationship, right, but the marriage could not take place due to the differences in their families. So because of the differences between their families, the marriage could not take place, right, and ultimately the complainant, she lodged an FIR against the petitioner under section 376 2N, that is for rape. So the complainant lodged an FIR against the petitioner for rape. Okay, the court said that in order to attract the offense of rape, the consent of the complainant must have been obtained on the false pretext of marriage. Okay, so in order to attract the offense of rape, right, and in order to constitute the offense of rape, or the consent of the complainant must have been obtained by the petitioner on false pretext of marriage. So basically the complainant must establish the fact that the sexual relationship between them was established, right, after the petitioner has induced the consent of the complainant on the false promise to marry, right, but this is not the case in the present matter, right, because no such intention was there, neither the consent was obtained on the false pretext of marriage, right. So this is not the scenario in the present matter. Okay, court relied on the case of Jyotirgavan versus the state, and in this case the apex court held that the false promise to marry does not automatically amount to rape, right. So unless the fraudulent intent existed at the time of consent. So at the time of the consent, so when the petitioner has obtained the consent of the complainant, at the time the petitioner has the fraudulent intent. Basically he was fraudulently obtaining the consent of the complainant on the pretext of marrying her, right. So basically in order to establish the offense of rape, the pre-existing intent in the mind of the petitioner has to be there, right. The bench was of the opinion that this matter is an example where the criminal color has been given to a situation where consensual relationship do not turn out in matter as desired by the complainant, and the same cannot be allowed by court, right, because see here no such scenario of fraudulently obtaining consent was there, right. Ultimately the complainant was giving criminal color to such a situation, right, and this amounts to the abuse of process of law. So this her act of giving criminal color to such a situation is the abuse of process of law, and the High Court ultimately quashed the FIR lodged against the petitioner and state that merely because the relationship between the two consenting couples, it ultimately do not culminate into the marriage as desired by the complainant, right, so it cannot be made a basis for instituting a criminal proceeding. So basically since the things did not happen as per the desire of the complainant, right, we cannot make it a basis to ultimately institute a criminal proceeding, and therefore the FIR is quashed by the High Court, right. So this is what happened in the case. Thank you so much.